Today we are going to be looking at the area of discharge of contract. When the duties set out in a contract between the parties are performed, the agreement is said to be discharged. A contract may be discharged in a number of different ways. Discharge by performance. As we have seen, where both parties perform their respective duties under a contract, the contract will be considered as discharged. Although under the entire performance rule, full performance of the obligations set out in the contract is in principle necessary for a contract to be considered discharged, under the notion of substantial performance, if minor duties remain to be performed, the contract may still be regarded as discharged, although damages are owing in lieu of the unperformed duties. Prevention of performance. If a party attempts to perform its obligations under a contract, but is unreasonably prevented from doing so by the other party, then performance is considered to have taken place and the contract discharged. Vicarious performance. The general rule is that a party cannot object to vicarious performance, i.e., performance of the obligations in the contract by a third party, unless such performance is prejudicial to their interests. Where performance by a third party does occur, liability as regards the performance rests with the original contracting party. Parties to a contract normally include a non-assignment clause in their agreement so as to prevent or to control third-party involvement in the execution of the contract. Discharge resulting from the mutual agreement of the parties. An agreement may be discharged by mutual agreement in two principal ways: waiver and novation. Waiver. By waiver we mean a relinquishment of a contractual right. A decision to waive performance may be either mutual, where both parties waive the other's duties to perform, or unilateral, where only one of the party waives his right to performance by the other party, i.e., a party is given permission not to perform by the other party. A mutual agreement to waive performance will be binding on both parties as the necessary consideration is present, the consideration being each party's respective promise to waive performance by the other. However, a unilateral promise by one party to waive the other's duty to perform may pose problems, as the court might consider the promise to waive as not binding unless it is supported by consideration from the party benefiting from the waiver. Now let's look at novation. Novation can occur in the following two circumstances. One, an obligation under a contract, or the contract itself, is replaced by a new obligation or contract, or a party to the agreement is replaced by another party. Discharge by anticipatory breach. If a party X in a contract with party Y, through word or deed, declares, prior to performance falling due under the contract, that it does not intend to execute its contractual obligations, X is said to be an anticipatory breach or anticipatory repudiation of the contract. In such a situation, Y, the other contracting party, may immediately sue X for non-performance and need not wait until the actual date that performance is due in order to bring an action. Discharge resulting from fundamental breach of a condition of the contract. Non-respect of a material, fundamental condition of the contract will justify immediate termination of the contract by the other contracting party. Discharge under the doctrine of frustration in the UK, or the doctrine of supervening impracticality in the US. Frustration is a doctrine developed by the common law courts. As the common law courts did not develop the doctrine of force majeure, if the parties wish in their agreement to be the subject of a force majeure exception, they will have to include a clause to that effect in their agreement. To the contrary, the doctrine of frustration, the courts will apply to the parties' agreement unless their contract specifically provides to the contrary. So what are the differences between the doctrine of frustration and force majeure? Although similar, the two notions of frustration and force majeure are not the same. Indeed, to a certain extent, they are fundamentally different. Frustration. Under the doctrine of frustration, a party will no longer be liable for performance if the performance becomes too onerous, impractical, or impossible, either objectively but also subjectively, i.e. from the point of view of the parties. The underlying rationale behind the application of the doctrine of frustration is that the character of performance for the parties has changed radically, justifying subsequent non-performance. Under the notion of force majeure, a party will no longer be liable for performance where the performance is no longer objectively possible. Thus, force majeure is centered on an event and whether the event renders performance impossible, whilst frustration is not just measured by reference to the event, but also takes into consideration the party's appreciation of the event. As a result, the doctrine of frustration also applies to events where the nature of performance, as anticipated by the parties, has changed radically, even though actual performance in accordance with the terms of the contract remains possible. There are other differences between force majeure and frustration. Frustration, when operable, will normally bring the agreement between the parties to an end. To the contrary, an event of force majeure may either terminate or suspend the agreement between the parties, depending on the nature of the supervening event. Under common law case law, no rights or duties exist after the frustrating event has occurred. The transaction is said to be frozen in time, and thus, for example, money transferred prior to the frustrating event does not have to be returned to the other contracting parties. To prevent parties benefiting unduly from this situation, the UK Frustrated Contracts Act of 1942 provides for a restitution of any monies paid prior to the frustrating event. However, the parties may, if they choose, exclude the application of the Act in their contract agreement. Moreover, the Act does not apply to contracts concerning the carriage of goods by sea or insurance contracts. And finally, if the event has previously occurred in the past, it is difficult to claim force majeure as it only applies to unforeseeable events. However, in the case of frustration, the fact that the event has already occurred previously will not necessarily prevent the courts giving relief under this heading. For the courts to apply the doctrine of frustration, it is necessary to show that the event was not provided for and dealt with in the contract between the parties by way of a hardship clause, and that the frustration was not self-induced. There is a significant amount of case law on the notion of frustration that can be regrouped under three main headings, namely illegality, change in the character of the agreement, and impossibility. Illegality. Where the law interferes or prevents with the operation of a contract that was entered into prior to the application of the law, the contract will be considered as frustrated. An example would be where a merger agreement between two companies is subsequently prohibited by the competition authorities pursuant to applicable antitrust law. The merger contract will be considered as automatically frustrated the moment illegality attaches to the transaction. Now let's have a look at a significant change in the character of the agreement. In the opinion of the courts, the underlying rationale for a finding of frustration under this heading results from a failure of something which was the basis of the contract in the mind and intention of the contracting parties. The case of Krell and Henry is illustrative in this regard. In this case, the plaintiff agreed to let a room to the defendant in order that he might view the king's coronation procession. Although not specifically referred to in the contract, it was understood by both parties that the purpose behind the letting of the room was to allow the defendant to view the coronation procession. When the coronation was cancelled, the plaintiff sought to exit the agreement on grounds of frustration. The defendant refused, claiming performance remained possible. The court held the contract to let the room was frustrated as the coronation, even if not referred to in the agreement, was the foundation of the contract. And finally, let's have a look at the notion of impossibility. Impossibility can occur in a number of different circumstances. For example, where the subject matter of the contract is destroyed, or where there is a vital change in the circumstances as regards the method of performance. It is important to note, however, that a contract will not be considered to be frustrated where a change in the circumstances merely renders the agreement more complicated to perform. In Taziruglu Company and Noble Torl GmbH, the fact that the Suez Canal was blocked and that a ship had to instead go around the Cape was not held to frustrate the contract. For a change in the manner of performance to lead to a finding of frustration, it is not enough to show unexpected inconvenience or hardship as regards the performance. There must be as well such a change in the significance of the obligation that the thing undertaken would, if performed, be different from that contracted for. Frustration is referred to as the doctrine of supervening impracticality in the US Uniform Commercial Code, but effectively operates in the same way as the UK doctrine of frustration. In order to prove impracticality in the US, it is necessary to establish that 1. An event occurred that makes performance, or performance in the sense contemplated by the parties, impossible or impractical. 2. The party seeking relief is not at fault in causing the event to occur. 3. Non-occurrence of the event was a basic assumption upon which the contract was made. And 4. The party seeking relief did not assume the risk of the event occurring. We hope you enjoyed this introduction to the area of discharge of contract.